brief argument. The Honorable Mr. Bailey, then District Attorney in Fulton County, said, Your Honor, the defendant has filed this motion through his attorney, Mr. Steele, challenging, while seeking to suppress evidence in this case that was collected from Mr. Williams' home at the time. The basis of this motion is, and the Honorable Court interrupts, the only thing he's challenging is marijuana, which is what the state seeks. Mr. Bailey says on line 23, right. The basis of the motion, thank you, Judge, the basis of this motion is essentially that, in the motion filed by the defense, that law enforcement officers did not have the right to enter the home, did not have the right to enter the home to effect the warrant. Going down to line 3, it's on page 34, continuing. Mr. Bailey, the district attorney, on page...
Can I interrupt you a second?
Yeah, of course.
IT is about to create a new secure Zoom link, but it's only for the attorneys. You're not to share the link. You understand me? Good? All right, thanks. Okay. I'm sorry. Continue.
That's okay.
I apologize.
On page 3, 34, Your Honor, of Court's Exhibit 2, line 3. This is Mr. Bailey, the district attorney at that time, or senior assistant district attorney. On page 3 of the motion, it states, colon, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entering Mr. Williams' home. Then there are two parts here, and that's the long and short of it. Did they, meaning police, have the right to effect the arrest warrant, and what did they see once they got inside that would rise to probable cause? Then, skipping, Your Honor, to line 21, same page 34, this is Mr. Bailey again. Normally, officers can't just walk into folks' homes. That is well established, but there is a carve-out for affecting. Officers have reasonable belief the individuals inside. So it is not this way the state is saying that it's only somehow marijuana. I challenge the entry into Mr. Williams' home. When law enforcement went in home, they allegedly found marijuana, guns, other contraband, and that's when eventually the seizure of all of Mr. Williams' electronic devices that I've challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said, at the end of line 1, Your Honor, or it's the middle of line 1, an arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is. The state is saying the entry into Mr. Williams' home was unlawful. He has his constitutional rights violated. He's a victim. The court should say respectfully, no way, this would litigate it. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door, and they, meaning the police, Your Honor, detained him, meaning Mr. Williams, then Mr. Steele would be completely correct, and they could not enter the home. They effected the arrest warrant. Then skipping to line 19, Your Honor, page 36. So they have all clear lawful authority, talking about the police, to go in to effect the arrest warrant. And then we get to the second point, and it is in the same Wall case. Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in plain view. I challenge that law enforcement had no right to go into Mr. Williams' abode. And then the prosecutor on page 36, line 25, concludes, that is exactly what we have in this case. Once law enforcement is inside, they see marijuana on the coffee table in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom, and Detective Gaither further testified there were guns located in the living room. So That is, I challenged, I had a hearing, we won the hearing, it was a final judgment, not appealed. I am not respectfully required to do it again so the state can bring their A game, lose, and then bring their A plus game and try to win before this court. That's not the way, I don't get to do that, ever.
But it wasn't appealed. I mean, there wasn't, Judge Newkirk's ruling could have been appealed by the state, or could have been appealed by you within 30 days of the entry of the order.
Why would I appeal it?
Well, I know you wouldn't appeal it, but.
And the state doesn't appeal, what does that mean? It becomes final. The court cannot amend that order. You'd be amending the finding between the same parties on the same exact issue. They don't get the second, in the case law, it says second bite at the apple. Then, Your Honor, on page 38, line 14, this is the district attorney again. So it's just not an issue that makes any distinction or any difference. It's clear here that it's clear here they, meaning the police, had authority to go in to effect the arrest warrant because Mr. Williams wasn't outside the house and he didn't come to the door. Once inside, law enforcement saw illegal contraband drugs. That is probable cause to get a search warrant all day long in any jurisdiction in the state. Your Honor, the police had no right to enter. That ruling was made. I then say on page 39 of the same Court's Exhibit 2, line 1, I get to speak. The court gave me the opportunity to speak. I said, thank you, Your Honor. Your Honor, we are traveling under, I'm assuming the court has it. If not, we'll get you a copy. There was a supplement to motion to suppress, and this is what I'm stressing, sir, the Honorable Judge Glanville, any and all evidence located the way you're being told by the Honorable District Attorney's Office. This was not about, oh, the judge only suppressed marijuana. That is just patently a intellectually incorrect way to interpret this. On page 39 of that same transcript, line 25, I continue. First, 1, there is no certified copy or any copy of an arrest warrant in DeKalb County under Baez, which the court already spelled B-A-E-Z versus state. And then we get into that arrest warrant. And then say on page 40, Your Honor, line 10 in the middle, is that if there is no arrest warrant, the police entry into, and I said, appellant's home was unlawful. Arrest would be unlawful. And then the fruits of the unlawful arrest may not be introduced into evidence. An arrest warrant was never part of the record below. An arrest warrant not put in evidence was not put in evidence while the witness testified or at any other time. The participants in the suppression hearing refer obscurely to the warrant, this warrant, the warrant in the case. But there is no document to show that there is an arrest warrant. No judicial officer testified that he or she issued an arrest warrant. If the arrest warrant in existence, no reason whatsoever appears for the state's refusal to put it into evidence in the face of a demand. And I continued, I didn't write, I spoke, page 41, line 1, Mr. Williams demanded in paragraph 7 of the supplemental motion and challenge that there is an arrest warrant. If there's no arrest warrant introduced in the hearing, then we go down the road in kind of an outline. So if there's no arrest warrant before this honorable court, which there is not, then law enforcement officers, according to Sergeant Gaither, 30 or 35 law enforcement officers surrounding his home, Sergeant Gaither, which is G-A-I-T-H-E-R, did not go into the home. However, law enforcement officers entered this home. This honorable court has no evidence that they entered lawfully. Supposedly, he goes into Mr. Williams' bedroom. Now Mr. Williams is outside. So my first issue is the initial entry without the arrest warrants vitiates everything coming afterwards. That was my argument. On page 42, line 12, I argued to the Honorable Judge Newkirk. So my issue, I said right, period. So my issue before this Honorable Court is the first entry, obviously without the arrest warrant at this hearing, is unlawful. Then the second can't be saved by the second entry either, because that would be without lawful blessing, same thing as unlawful search, the second one we're talking about. Then the search warrant issue, this would be my third issue. So first one, no arrest warrant. I am challenging, it is clear to everybody, including when you read the state's motion for reconsideration that I've already entered, Your Honor, at the last hearing, everyone knew I was arguing that the entry into Mr. Williams' home was unlawful, and therefore everything in that home could not be taken, should have been suppressed and returned to Mr. Williams. And the state's reliance on Alford, State versus Alford, the state's reliance on this narrow window that only the Honorable Judge Newkirk suppressed marijuana is frivolous. On page 43, starting line 4, I continued. But then when the court goes through and looks at the search warrant itself, the only way we would have probable cause in the search warrant is if the court finds that law enforcement officers on the day that this happened actually had the lawful right to go in the house and to observe, because everything else in that search warrant does not produce probable cause to search Mr. Williams' home. Then it continues on page 45. On line 4, at the end, I say in the middle of the sentence, nothing is attached showing that this arrest warrant was valid from DeKalb County. On line 40, page 46, on line 5, the next issue, Your Honor, that is asserted is that law enforcement officers entered Mr. Williams' home on the day that we're talking about, and I challenge that in the supplemental motion with the fact that it was read to this honorable court by the district attorney, supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home. I'm challenging the arrest warrant was not valid if there is an arrest warrant. And the last issue in the affidavit for the search warrant discusses items that were located by law enforcement officers during the search on the day that you heard about, which I would say is a fruit of the poisonous tree. So I have 3 issues. 1, there is no at all arrest warrant presented to this court. So under Baez, which I have a copy for the court, how can I challenge the arrest warrant? How can the court say it's a lawful arrest of Mr. Williams at his home without being armed with a certified copy of the arrest warrant? Therefore, and I stress this, Your Honor, everything thereafter falls as fruit of poisonous tree. On page 47 of the transcript in courts number 2, on line 9, I continued. So the only thing we're left with is the unlawful entries into Mr. Williams' home, and I would ask the court, based upon that, suppress the evidence, grant a motion to suppress. Mr. Bailey then speaks on page 47, line 14, and going to line 18. At the last word, he says, this motion to suppress the search of a home that the defense is alleging is illegal. Nobody's talking about only marijuana. Mr. Bailey continues on page 48, in line 10 in the middle. The only 2 questions, Your Honor, are, did they have reason to believe Mr. Williams would be there, and so they could go into the house and get him? That's it. And then secondly, once they're in the house, did they see something that would give them probable cause to obtain a search warrant? Those are the two issues, not whether the arrest warrant out of DeKalb County was valid and whether the case was eventually dismissed or anything like that. The court then, on page 49, on line 6, says to the state, in which case you would have produced a copy of the arrest warrant. And Mr. Bailey says, right, which would have been a subject, I'm sure, of the suppression motion at that point. And then the Honorable Judge Newkirk said, well, it sounds like Mr. Steele made the arrest warrant a subject of this motion, also in a supplemental motion which the court file does not have. What does it, what?
We still lit it, gang. Seeing what's going on, we still lit it, though. Yeah, thug in court, gone out. Thug in court and gone out. What y'all thinking about the situation? What y'all think about the situation?
About DeKalb arrest warrant, if he wants, there's no need to challenge the DeKalb arrest warrant now because the case was dismissed. But there is a forum for doing that, and that may be what they did in the case. Maybe they challenged the arrest warrant in that case. On page 51 of court's number 2, the district attorney states on line 6, that doesn't mean that because there's not a certified copy of that arrest warrant that has any bearing at all on whether the entry and subsequent search of this house was proper. Everyone's talking, Your Honor, about the entry. That would be the state's argument in the case. At line 11, the Honorable Judge Newkirk said, all right, tell me again about Baez. I'm not familiar with it. What is the site? Is it Supreme Court or Georgia Supreme Court? I say Court of Appeals. I give the court the site. And then on line 51?
51, okay.
Yes, sir.
All right. Yep.
And then on line, the court asked me for a summation on Baez again, and I said, okay, that's on line 22. So it's a motion to suppress like we're dealing with here. Law enforcement officers have obtained a search warrant after an arrest warrant. So it's the same sequence here. Going on to page 52, Your Honor. Law enforcement officers utilize the arrest warrant. They call it several things, bench warrant, arrest warrant, and just like Mr. Williams, it was challenged whether it was a valid arrest warrant. The motion to suppress hearing goes forward. The prosecution doesn't put forth the arrest warrant. The Court of Appeals says without the arrest warrant, it is not in the record. We are not finding there was an arrest warrant. It was challenged, and they suppress the evidence and find it is a fruit of, since there's no basis in the record to have an arrest warrant, everything thereafter is unlawful. That's exactly what I think happened here. That's why I used the case. Why did I make the supplemental motion to suppress all evidence located from Mr. Williams' home? Your Honor, I was challenging everything. It is clear. And I'll get to the Judge Newkirk's order because it's not a fair reading of the order to say only the marijuana. That's not true. I didn't write that order, by the way. On page 52, line 23, I say, and I don't want to play games with anybody. I put it in its own paragraph. I made it a supplemental because I realized there was a problem with the arrest warrant. So I made paragraph 7 standing alone, or standing on its own, and I wrote, moreover, law enforcement officers were not armed with a valid arrest warrant in DeKalb County at the time of entering Mr. Williams' home, and thus, and Your Honor, I'm stressing this, all evidence must be suppressed on page 53, lines 1 through 5. Then skipping to line 15, I again plead to the Honorable Judge Newkirk, the law should be followed in this case, and I say, but I guess it goes back to if the first arrest warrant is not before this honorable court, according to Baez, it was challenged, just like I challenged it on behalf of Mr. Williams, then how can this court sit here, the evidence that you heard, and say, well, there's a valid arrest warrant? We challenge that there's no valid arrest warrant, and then it's not saved later, in my opinion, the search, because I don't know how else law enforcement gets in the home because now, you know, thank God there's not a shootout in the house where law enforcement had to go there. On page 54, line 5, Your Honor, I continue. So I don't know how law enforcement, without a valid arrest warrant here today, has any evidence to go before the court, and that is why I made an issue of the other items in the search warrant, like the confidential source, the alleged confidential source, the murder of Mr. Thomas, because all of that doesn't save the search warrant, so that's why I thought it was important. The court states, the Honorable Judge Newkirk, on page 55, its ruling. On line 18, the court says as follows: all right, Mr. Steele, I'm going to go with you on this. I think you are correct. I think the burden is on the state to show the initial arrest warrant was valid and initial entry into the house was valid. And he hasn't done that, meaning the prosecutor has not done that. It appears there's no testimony from any officer. Certainly, there's no need for her to go back in the house without a search warrant. It doesn't sound like she searched for anything, so that might have been harmless, That might have been harmless error because the arresting officers discovered it and went out and told them. And this is what I'm stressing. Line 4, page 56, the Honorable Court's ruling. But I don't think we get to that hurdle because the lack of authority shown to the court that they had permission, meaning the police had permission to enter the house on the front side. So I will grant your motion, Mr. Steele, if you will prepare a proposed order. I never did the proposed order. I don't know why I wouldn't do that when I'm told. Maybe I did and the judge didn't like it. That's not my order. The bottom line I'm trying to tell this honorable court with as much earnest and power and professionalism as I can is I do not want to relitigate this after I gave a roadmap to the prosecution on how to litigate. If they need me to help them litigate a case, I'm not helping them. The issue here is we had the hearing. I challenged the initial entry into Mr. Williams' home. He is the victim of constitutional rights that have been violated, and the state doesn't get to go back and do it again. Then Judge Newkirk's order. If you look at his order carefully, Your Honor, he does not just suppress the marijuana. The prosecution, and they're great people, but on page 33 is all they want you to do, Your Honor. They want you to be in your foxhole and just focus with tunnel vision and say when the judge said all he's challenging is the marijuana and act like, well, that's all there was. The judge found that the entry was unlawful. We don't get to do it again. And Mr. Williams then tried for a year and a year to get back his property. And what did the police do? They tell him, it's the evidence. We're not giving it to you. The statute says it. And now, today, the state wants to come in and say, well, we had another search warrant. I will talk about that search warrant in a moment. Let me just tell you, if you don't mind, the order of the Honorable Judge Newkirk, which I forget the number.
It is D4.
And Your Honor, in the...
That's the first one.
Thank you, sir. And it's entitled, it's filed, I know the hearing was on the 3rd of April, 2017.
Filed in on the 11th of April,
Right.
2017.
So D4, order granting supplemental motion to suppress, and I'm stressing it, any and all evidence located from defendant, It's Mr. Williams' home. It says, it's used defendant's home. After hearing testimony, a stipulation of testimony, an argument from the parties on Monday, April 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. There is nothing clear in the world of what was suppressed. The prosecution is intellectually not being straight. Based on this ruling, meaning everything's gone, the evidence located in Mr. Williams' home that is subject to this accusation, that's all, the accusation was just a marijuana case. Specifically, just over an ounce of marijuana is hereby suppressed and cannot be used in evidence by the prosecution in the trial of defendant Williams. Do you know where the judge got that language from? I know I didn't do this order because I would always say the Honorable Court. This is just not the way I'd write an order. But you know where the court did get the language of what the state wants to rely on, specifically just over an ounce of marijuana, it's in my motion. I said suppress everything, specifically including the marijuana. It is not true what they are telling this honorable court, and that's not acceptable. Then you go to the search warrant. The state wants to rely on a search warrant from 2016. It was signed by the Honorable Judge Woodson. It is signed, and it's in your court's file. I believe it's defendant's number 10, I'm going to tell this honorable court. And it was signed on June 27, 2016.
I have the warrant for search and seizure as D10. You introduced that last time.
So, Your Honor, this is the same items that were taken from Mr. Williams' home in July of 2015. It's the same exact items that should have been returned. The state of Georgia has a search warrant. What they don't tell you, and I'm not saying they're hiding it, they just didn't tell you, is that they couldn't get into Mr. Williams' devices. They sent it to Cellbrite with the search warrant. And Cellbrite wrote back, and the GBI, we can't get in the devices. The search warrant then is never applied for again to tell any court, like this court, by the way, there was a hearing and all the evidence was suppressed. The state is using then in May of 2017, after Judge Newkirk suppressed the evidence in April of 2017. The state then sends Mr. Williams devices when they won't give it back to him. They won't restore it to Mr. Williams or his father, who had a power of attorney. They go to Cellbrite, and Cellbrite now has better.
Yeah, we still here with it. What y'all thinking of it so far about the Gunna being free and Young Thug facing the judge? Do y'all think Young Thug will soon be home? What y'all think? Do y'all really think Young Thug will soon be home? Or they got their foot on their neck? They ain't trying to let him go right now. What y'all thinking? We see Gunna come out of jail. He running out of there holding his head down like he don't want to be seen. So we really don't know what's going on with it. Is Gunna snitching? Is Gunna snitching? You know, everybody thinking Gunna snitching. They got his name running across the screen. And this and that about it. We don't know yet. We don't see if he testify. We'll get back to it.
Not executed within 10 days from the time of issuance shall be void.
Mr. Steele, sorry. Mr. Steele, go ahead, sir. Yeah, go ahead, sir.
(17-5-25), the last sentence that the legislature taught us. Any search warrant not executed within 10 days from the time of issuance shall be void and shall be returned to the court of the judicial officer issuing the same as, quote, not executed. The state doesn't have a search warrant in 2017 in May. They steal Mr. Williams' property. They illegally enter his home. They steal his property. Then they keep it, the stolen property. They keep his the property that they stole. And then they go to Cellbrite and they ask him in May of 2017, after everyone's on notice that the motion to suppress was granted, not even appeal. They didn't have the guts to appeal it. And say collateral estoppel, res judicata, law of the case. It should have been restored. The police should not have had that evidence. It should have been given back to Mr. Williams. He shouldn't even had to ask for it. And I think that State versus Alford, I'm sure the court has read it. It is telling the court something that the case does not discuss. It is just not even arguable that that case matters to this. They had additional reason to go into the home, into the car in Alford. They had the automobile exception. That is my argument when you asked me. I hope I answered your question, and I thank. I'll answer any other question, but I hope I answered your question.
You did, sir. You did. Ms. Rosenwald?
Your Honor, I know Mr. Steele has an interpretation of the language of the order.
I think that his interpretation is right. I'm just going to tell you that. I mean, I look at the way it's capped, its style and everything else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at the marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time, and it's clear in the transcript that he did in fact assert the fruit of the poisonous tree. I mean,
so Your Honor, if I may, when I looked at this case first and I saw his motion, I was sort of thinking the same way as the court, and then I thought, I'm going to check the case law.
The judge is not buying it.
Thinking it might be something different, and whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the fruits of the poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here. We're talking about him now challenging a search warrant that was not challenged before. And I think
though. That's the thing about it. I mean, I think it's clear from reading the transcript and the exhibits 1 through 10 that were admitted when we were here on the 17th of November that he challenged everything: the arrest warrant, the search warrant, and he, in fact, he filed a supplemental motion to that extent. So Judge Newkirk granted the marijuana was only the subject matter of what you prosecuted him for at that point in time. You had other things that were seized. Those things are fruit of the poisonous tree, or at a minimum should have been returned to Mr. Williams.
And so, Your Honor, I do want to pivot that if this court right now today says, hey, I'm wrong, and Your Honor finds that the cell phones are fruit of a poisonous tree, now and only now would Mr. Williams be able to demand his cell phones back. There has never been a ruling on the cell phones until this gets really clear from the court's language in the transcript, specifically in the transcript.
I think they don't even have a cell phone. I think they don't have a cell phone.
It doesn't sound like she searched for anything. So that might have been harmless error because the arresting officers discovered it and went out and told them. But I don't think we get to that hurdle because of the lack of authority shown to the court that they had permission to enter the house on the front side. to that hurdle. There is no ruling on fruit of the poisonous tree. There was no previous ruling on the cell phones. To the extent Mr. Steele wants to make an argument about the other search warrant in the other case, that other search warrant, we can do that today. We have the witnesses here. If this court can make a ruling whether that search warrant was proper. And we have testimony. We will explain the delay. We will explain that there was not the appropriate software available at the time of the warrant. We'll explain why all of that was lawful. But there's been no time to litigate that. The question now is whether there was a previous ruling on the fruits of the poisonous tree, and Your Honor, there just wasn't. And Your Honor, we have here the law enforcement, I do mention this briefly in my case, there was no finding that his rights were violated. There was a finding that the state did not meet its burden. Here, the officers acted in good faith. Again, we are prepared to show that there were proper warrants for everything. We haven't had that opportunity yet to show as to the 2016 cell phone warrant. We're ready to do that today. Now, Your Honor, there has just been absolutely no ruling as fruits of the poisonous tree. And if the court were to find
Well, she talking about it, but why she ain't showing it? She talking about what they got. She sure ain't pulling it out. We willing to show it today. Well, show it. Show it. You talking about it? Show it. We ain't seen it yet. She just standing there. Oh, we got it. We can prove that today. No, don't talk about it. Be about it. That's what the court for, ain't it? Don't talk about it. Be about it. Go on, show it. You go on, show it. They talking about it. It just what y'all think about it? What y'all think about it? See the third lawyer standing up doing their thing. The prosecutor don't know what they got going on. I don't think they got a 2016 warrant. Why one presented to the court? Well, they had to go back there and type it up. You gotta watch them now because they're very slick. Folks probably went straight to the back and typed it up. You never know. Probably went straight back there and typed it up and ran it off. And they ran. She sitting up there. She buying time right now. She's sitting up there buying time as we speak. Get it? Buying time. That's the only thing she's doing. They'll run it to the front after a while. They'll be coming through the door with it. That's through the email. They might and the printer. We'll get back to it.
Used in evidence in the trial shall be returned to the rightful owner. All personal property in the custody of a law enforcement agency, including personal property used as evidence in a criminal trial, which is unclaimed after a period of 90 days following its seizure or following a final verdict and judgment in the case of property used as evidence, which is no longer needed in a criminal investigation or for evidentiary purposes in accordance with 17-5-55 or 56 shall be subject to disposition by a law enforcement agency. So this one is different, different than 17-5-30, which is pre-trial. So this is this is trial evidence, what we do with evidence after the trial of the case. So that, and I mean, I still have an issue of that because you would have still had to return his property to him.
Your Honor, I'm sorry. I have to respectfully disagree with the court. Here, it's not a situation of what Mr. Steele challenged at the previous motion. It's what was ruled upon. There was no ruling upon the.
So if I had $200 and this situation happened, you wouldn't have to return the $200 to me if I won my motion to suppress?
Your Honor, if I had a search warrant that was valid, currently being executed for your $200, and it was for a separate investigation, a separate case, my position is that no, I would not have to return it until that separate investigation, that separate case was done, because I had a valid search. And obviously,
do you have some case law that interprets 17-5-30 in terms specifically the possession of which is not otherwise unlawful? Because that to me says that would be any contraband, weapons, or things that you're not required to, not allowed to otherwise possess. But it doesn't distinguish on investigations or you holding on to evidence that otherwise should be returned.
Your Honor, I don't have a ruling at a case at this time. I'm happy to provide that in a supplemental filing. But again, my understanding of the law is and has been that where there is, if a search warrant is currently being executed on a cell phone, for instance, the police are allowed to retain that property as part of an ongoing investigation.
But he won the motion to suppress.
On the marijuana case, Your Honor, not.
But you took more than the marijuana. He wouldn't get the marijuana back anyways. He wouldn't get any cocaine that came back anyways. He wouldn't get a gun back if he's a convicted felon. But anything else that was proper, that was taken from that particular, house subject to the warrant, that's not otherwise illegal, is returned. The 17530 says shall return and not be subject to further prosecution, because that's the whole thing about it is you don't get another bite at the apple based on this particular evidence. You can go ahead and do some, a separate investigation or whatever, but this evidence is supposed to be returned to the defendant.
Your Honor, our position remains that because there was a separate ongoing investigation for which a valid search warrant was in effect, and there was no ruling as to fruits of the poisonous tree, there was absolutely no reason to return that cell phone. I'm happy to provide the court with an additional brief, but that is our position at this time.
Okay. All right. I'm going to take 5 minutes, okay?
Thank you, Your Honor.
Okay. All right. We're going to be in recess for about 5 minutes. Okay.
The prosecutor do not want to let go, do she? The prosecutor do not want to let go, man. She don't want to let go. What's going on? She do not want to let go. Tomorrow, she gonna still hold the man's cell phone. She try to squeeze juice out of a tree, ain't it? She is wild. She is not trying to let go. Ain't presented no evidence, nothing. They ain't have no right to the reason they didn't take the man's cell phone. Y'all see how it worked? They put the charges on the people that had a district attorney fight the case on. It was wild. So far it look like they're going through a favor for the moment. Wonder how long it's gonna last. It look like it's going into favor for the moment. We'll have to wait to see what's really going on. He take a 5-minute recess. You got to see what's really going on. They got to go back there and work it up, huh? We don't know. We'll see when they get back on what's really going on. We'll see what's really going on. Oh, we ain't left the court yet. We're going to get back to it. Let y'all see what's going on inside the courtroom.
I didn't see it.
The judge will be back on the bench in a couple of minutes. The judge will be back on the bench in a couple of minutes. Yeah, I wonder where the prosecutor go when the judge take a recess. I wonder where the prosecutor go. Do they take a recess too, or they sit in the courtroom? What do you guys think? They go sit at a bigger round table. You know, I don't think the judge disagree too much with the district attorney. In some cases they may, in some cases they don't. Mhm. We'll just have to see when they get there. We'll know when they get there. What's really going on with the whole situation. You know, judge had to take a break. The prosecutors don't want to go. She holding on to any little thing. Trying to have something so small, turn something so small into something so big, probably. While gone somewhere at the house, watching the news, hoping his name will come up. Probably sitting there eating a honey bun. You know, shortage on the mug in jail. He's somewhere on the couch eating honey bun, watching TV. Wishing he had did what he did. Probably couldn't even get into the studio nowhere. Everybody still up like, no. It's gonna take a while. You know what I'm saying? It's gonna take Thug to get out of jail and say, oh yeah, is everything all good? He ain't tell. I think they're gonna have to hit a word from Thug. They're gonna then snitch before people get to messing with him. We don't know yet. I seen him everywhere. They say he spoke out. We're going to go find that and see what Gunner had to say. I know one thing when he came out of the jailhouse, he had his head down. He was trying to run from them cameras. But he ain't come outside today. He still laid up somewhere. Real talk, enjoying every moment of the house. Know how them sales get. On small thing. Yeah, he's somewhere right now, probably drinking milk, eating honey buns. Glad he out the situation. Man, that was your boy, man. You could at least held up for the drugs or something. You didn't hold up for nothing. You just took off the running. Yeah, gave your little speech and you took off the running, man. You could at least, oh yeah, you know, that little bit right there was in the car with mine. You know what I'm saying? On some real, you know, keep it in 1K. You know what I'm saying? To make a little light on your homeboy. Man, that man is selfish. The man is selfish. I don't know why he's so selfish. Man is selfish, man. The man didn't think about nobody but himself. The way he ran up out of there. Real talk, I think it would have been my homeboy, man. I could have at least been like, oh yeah, man, that there ain't none of his, that there ain't none of his. Oh, that mine's right there. You know what I'm saying? Made a little light on my homeboy. Man, this man didn't care. He come about the jail running, thinking about nobody but him and baby. Real talk. Thinking about nobody but him and baby. Now ain't gonna be hard for him to get in the studio or anything. He probably don't care no way. As long as he home, he'll think of another way to get some money. His feet just didn't touch the street. That's it. 50 Cent heard. I see 50 said, what you gonna do when you get home? You know? Which is a good question. What you gonna do when you get home? You already labeled a snitch. Who finna mess with you? Ain't too many people gonna mess with you. They running from you. They ain't trying to be caught up in the Rico conspiracy dealing with you. Or you going somewhere busting the case on them for your freedom. Lots of people want to commit a crime, but they can't hold up for them. No, they can't hold up for them. When the greasy get hot, they running. Yeah, when the greasy get hot, they running. They big gangster. Oh yeah, and Gunna been talking about pushing P. That what the P doing? That what the P do? Okay, pushing P. He thought he was doing something. He made that song. Slick disrespectful. Pushing P. Okay, P. You went P in that court. On the P you were doing, taking a plea bargain. Think that's the only P you know, playing out. Real talk. Only P you believe in, playing. Yeah. And patting their feet, getting up out that jail. Real talk. Excuse me, I got the puppets in the background. Yeah. The man talking about pushing P, but can't hold up when it come down to it. Ain't taking nothing off your partner. Left your partner there to drown. I'm talking about, they ain't tell the people, oh yeah, that little bit there was mine, that little bit. I'm talking about, man, probably not even a convicted felony. Well, at the time, probably was not even a convicted felony. He couldn't even hold off for a little bit of nothing and made it light on his homeboy, the person who seen the best in him. You know what I'm saying? His right hand man. You know, people selfish out here. You know what I'm saying? I think he would have blown up first. He probably wouldn't have gave Thug a chance. You know what I'm saying? From the looks of it. Exactly from the looks of it. I think a judge went over a little bit of 5-minute break, didn't he? He went a little longer than that, didn't he? The judge had to go back there and drink him some coffee and pop him a Rockstar energy drink before he come back out of there. Too disturbed, especially when you're dealing with this, I guess she the prosecutor, this little lady here with the little whining voice. I guess she the prosecutor, I don't know. Y'all know what she is. Drop down and let me know what she is. Is she the prosecutor? Don't look like she no attorney or nothing. A district attorney. What she look like? Yeah, but she ain't trying to let go of nothing. She holding on tight to every little thing. Every little thing. Hoping she can present the case further than where it at now. Probably wishing she could send it somewhere to the probably think she wish she could send it to the feds. Probably have already. I heard Bruce say when you beat the Rico, you know what I'm saying, you gotta worry when you walk out of jail because the feds will be there waiting on you. Yup, but the state ain't have enough, well, not saying they ain't have enough evidence, but they ain't know how to prosecute the case. I'm assuming so that Fed will pick it up. You know, a little more advanced than the state. And as we know, this is a state RICO case. It's not federal, I don't think. Or that is the federal RICO case. I think it is on the state. There's lots of motion going around in court. I'm just waiting on the judge to hit the bench because I really want to know what really going on. The judge, you know what I'm saying, stomach must have been messed up this morning. Well, 2 o'clock in the evening this afternoon. A 5-minute break went into a 10. A little motion going on around, huh? As y'all can see, they're just standing around doing nothing. Talking about nothing. Yeah, y'all got to excuse the judge went out for recess. He took a 5-minute break. I'm assuming he lost time back there. And kept the time walking off the bench and walking into the room. That time they counted off. Hold tight. The judge took a 5-minute recess. He'll be back shortly. all places they could have, all places they could have had a team meeting it while right there. Out of all places. Whereas we know the judge is on the way back. The judge on the way back in a couple of minutes. I wonder what's the judge energy when he get back. That's what I want to know. I want to know what the judge energy when he get back. Is the prosecutor working out a deal with him back there, or what's really going on? Because she kept saying, "Oh, we can present that today. We can present that. We can present that today." So we want to know what type of plan that the judge gonna have when he get back. That's the most main thing. What is the plan when the judge get back? We don't know yet. I'm just here to see. I want to see the energy that the judge got. What I want to see. I just want to see the energy of the judge. What y'all think the energy gonna be when the judge get back? And did the judge lose count? When the judge say he's gonna take a 5-minute break, do y'all think the judge lost count? Because as we know, it's been over 10 minutes. And the judge haven't made it back yet. I don't got no evidence on Thug, do they? You know how they play it when they get you in the court, they'll bring up any and everything on you. They'll probably have something new when they come back out. You know what I'm saying? They can't get you one way, they'll try to find another way. You know how they do it. You know exactly how they do it. They don't play. When they put you in their hands, they don't want to let go. They hate to let go. So we're going to give them a minute and see what's going on. As we know, it's been 15 minutes already. Not the whole, no, it ain't been the whole 15 minutes already, but it's been over his 5 minutes for sure. I think they're going to come back over to do playing. Yeah, they going back to the right to play up now, huh? Going to put together the play. We're going to see if they're going to score a touchdown. We're gonna see exactly if they're gonna score a touchdown or what they got planned. We'll sit here and wait. Give it a couple minutes. Judge will be back shortly. Okay, as y'all play about to quit. Okay, the judge said we're gonna take a 5-minute recess, right? And y'all see the lady who behind the desk to do the typing? Okay, so they're gonna take a 5-minute recess. The judge gonna take a 5-minute recess. Okay, we see she left too. Like she finna go take a 5-minute recess. But as we know that the judge been gone more than 5 minutes. As we realize she been gone longer than 5 minutes. So how long? Why? I want to know how long? How she knew that the judge went back in 5 minutes? What made her stay gone longer than 5 minutes? You know what I'm saying? That's what I'm saying. It's the people's in the back. It's the people's in the back plotting and planning. You know, it's the people's in the back plotting and planning. We don't know. We don't know. It's the people in the back plotting and planning because the judge finna be gone 5 minutes. The lady back there typing, she been gone 5 minutes. Over 5 minutes. So what, they having a meeting in the back? I don't put that past the court. I think it's all cricket to me. I think it's all cricket, to be honest. I think the court is all cricket. They gonna stick together. But as y'all can see, everybody gathering back up in court. So I think they're finna start it back. They're gonna kick it back off shortly. Keep the plot. See how the black man come through and let everybody know the judge back on his way? Y'all peep the plot. It's wild, ain't it? Look, even she back. The lady who typing. So it looked to me, they all, see what I'm saying? They all work together. How can you have a fair trial? I just don't see it happening. Look at her come back drinking. How can you have a fair trial? I don't understand it. Ain't nothing fair about the court. They had to have a meeting back there. I guess he had to go get on the district attorney. You know what I'm saying? We ain't gonna be arguing in the court. They doing it for TV. Let's get to it, man. See what they had to say about it. what's really going on. Let the court do its thing. Let justice run its course. You get the paperwork right now. They must have came up with the warrant and everything else. No telling what all they came up with. No, just repeat the play. No, we'll see how it play out. Just repeat the play. Yeah, you see, it's like I don't understand it. I don't understand how you get a fair trial. You're gonna need somebody to watch over the whole court. But here we go, we back, y'all. Y'all, people have to see. Do the judge got an earring and everything? Just check it out. Do the judge got an earring in the ear? He play. Judge against the truth. I think the judge bumped those. I think the judge probably bumped those. Man, they got an earring in the ear. Any quit. Check it out. The judge against. The military they just took a whole 20-minute break. He read over all that back there. The military they took a whole 20-minute break. And he still come out reading paper. So when back there, the focus went on the paper, the focus over and spreading the DA and everything goes. Everything is just how it go. Keep it on, let it through it, y'all. Don't look like to me he read no papers. He looking over papers. Just beat the play, y'all. He already know which route they going. They blind. Yeah, they what the whole up here. See, like they all blind right now. They'll be back up in the morning. We'll be back momentarily. They'll be back momentarily. Yeah, thug is he do the kill too. He ain't popping. Whatever that phrase, he be popping. He relax. He be popping too. He'll thug like a push. He be himself. They be gonna keep thugging this. Number friend, another girl gets out of me. You ain't got no friend. You gotta be stuck in a one man bed. Ain't no friend. You looking around all the time. Can't pay no nobody himself. Nobody himself. So far, what y'all guys think, man? What they call me, such let me know what y'all guys think. Hope you come in and know what y'all